right. Good morning, everyone. Welcome to our Lively U Virtual Learning Academy. Our presentation today is on the Constitution and its modern applications. Please welcome Judge Matt Reger here to share some information with us.
Hi, everyone. I guess I want to start out with this. When we left last time, I said that I would do a discussion on Citizens United versus Federal Elections Commission. And I did go over that case and then did not get all the information I needed to on that. And so I'm not fully ready to talk about that in its complete entirety. I think there's some complex issues in that case that I really wanted to delve into and to explain. And to be honest, I am just not ready to explain that today. I went through it and I want to give it the best. So what I'm going to do is talk to Danielle and see if we can maybe have another supplemental meeting to this where we just talk about that case. Because I think that case involves some really deep issues regarding the First Amendment, free speech, and what it means. I think that too, the problem with that case is that public media, public perception has turned the case into something more of a, what I would say, a political case, as opposed to what I'm reading it as is more of a legal discussion on the First Amendment and the protections of the First Amendment, particularly in regard to speech. I think that a lot of people see it as this money as speech issue, and I see it somewhat in a different way as a free speech or protecting free speech from some of the things that can get in the way of that. And so I just feel like there's some other issues that we should talk about before we really get in depth with that. I mean, last week, I threw at you some pretty complex matters involving the right to privacy. So what I thought is I'd like to really kind of open that up. We spent a long time during that meeting talking about Griswold versus Connecticut and the development of the idea of what's called substantive due process. And I used Griswold, as I said, because that delineated the strong differences that they have in regard to, is it stated in the Constitution, or is it, are you inferring that from the Constitution? I think we all fall into this kind of realm of thinking that, well, the Constitution's developed over time, and the Constitution is written in such a way that it can be interpreted over time and still look at what the original meaning was and what the original writing was. But what's the length of that interpretation? And I think that a lot of times people, when we get into these discussions, are inclined to say that they're open to having broader interpretation of the Constitution over time as things change, as society changes. I mean, I think we can all point to the fact that the society that exists today in 2020 is a completely different place than exists in 1787. And yet, at the same time, things are a lot the same in other ways too. So what I want to talk about, and I want to make sure that we have a discussion on this, is that there are some pitfalls to relying on the judiciary to just simply interpret the Constitution based upon cultural norms and the way things are now. Let's look at it this way. So those who believe or who hold to the idea of adhering to the written Constitution, what we call textualists, are saying, hey, what's written down is what we have to follow. That's what we have to rely on. The other side of the fence is, yeah, but things have changed a lot. Things are different now, and we can't just rely on that textual. And those are interesting comments to really think about. But think about this in the context of a free society. how do we feel about judges making decisions based upon cultural changes as opposed to what's written down? And so the idea is a separation of powers there is that isn't the legislature the one who's supposed to change the law and make the law different based upon cultural changes, and not so much the judges, that the judges are supposed to rely upon what's written down or what the written law is. And so that's maybe more of what the conflict is. But I really kind of, and I know I've talked a lot right here, but I kind of want to open up. I really want to see, this is really what we, what I kind of wanted to get out of this point was to get some discussion. So what I want to do is right now, just for a few moments, let's open it up and see if we can get a little discussion and then move it on to the next topic. Because one of the things I did not talk about, and I do want to talk about today, what I want to talk about today is the idea of, I want to talk about the Electoral College before we end today, but I want to talk about those 6 freedoms within the First Amendment. So I see a comment. The Constitution was written at least partly within a culture, including the Enlightenment. I agree with that. I agree that the Enlightenment did affect the writing of the Constitution. But here's my point is that if we say to judges, you should decide cases based upon cultural norms as opposed to what's written down, aren't we putting too much power in the hands of a judge? I think, I guess I would ask, and here's the starting point of this. Should a judge rule on a case based upon what he or she would like to see the result, or on what the law is? I mean, we may find a case that we like the result, but is it in compliance with what the law is? Now, we've seen sometimes where cases have applied a cultural norm. Culture has completely changed, and they have then reversed or overturned the case. And we've seen some good cases in that regard, and that would be Brown versus Board of Education. Stare decisis said that separate but equal was the law of the land, but Earl Warren and the court said, no, times have changed and we've got to change that. But I can also point to other cases where not going to the text of the Constitution is a problem. So I kind of want to open it up to that. I really want to see what you have to think. Here's a point. Well, the Supreme Court isn't always unanimous. I guess I have to believe they're doing the best they can in totality. I'm going to tell you, I think the Supreme Court does the best it can with the situations that it's given. It's given complex situations, and they're applying the law as written. And what they're trying to do is take what the intent, for example, what was the intent of the First Amendment? What was it meant to do in regard to free speech? And I think it's always good to look at that context and see what were they trying to deal with. They're trying to deal with the suppression of political statements in particular, but the ability of the exchange of ideas. There's a good argument out there that because of the First Amendment, ideas were now freely being exchanged in the marketplace of ideas out there. Now, there's some people who today would reject the idea of the marketplace of ideas or marketplace of speech. So I guess I would invite the comments on that or discussion on that. So it's up to you if you want to unmute and talk, or if you'd like.
Can't hear.
So when you say we must be careful what cultural norms are, America was founded on faith in God, I guess I would like to find out what the thought is there.
Oh,
Are you unmuted?
am I unmute? Can you hear me?
I can hear you.
Okay. Well, first of all, I want everybody to know that I do believe in God. Okay, not that that's here or there, but I do believe in God. But a lot of the founding fathers were what you call deists. They believed in a higher power, but not necessarily in God. And maybe that kind of makes this a little bit more challenging to discuss.
I think that's an interesting comment. I think that I think that a lot of people put a lot of eggs in that deist basket and say that.
Oh, okay. I'm probably one of them.
No, that's fine. I'm not trying to say that. Okay.
Okay.
No. Understand, there's a lot of influences, just like today, on people. I think it's hard to pinpoint one thing. In my studies, I would say, the things that I've read, I would say, in regard to Thomas Jefferson, there's no question. I think he was a deist. He wrote his own Bible that rejected the divinity of Christ. But he did accept that Christ was a very intelligent, very good human being. But he rejected the divinity. I don't know how much that, what that does in regard to his philosophy. At the same time, you have John Adams, who I think was a very faithful, devoted Christian, I would say. I would say Washington was somewhere in there too. And then you have a whole spectrum of people with different faiths.
Yeah.
And so I think that kind of, to just focus in on what their faith may or may not have been, I don't know that answers the question. What I'm trying to get at, and I don't know that I'm really answering it, but so I want to get it a little bit.
Sure.
Understand, I think, the danger in allowing a group of judges to, instead of interpret the law, make the law. So understand that, and this is one of the things I think that's interesting to talk about. Although we may agree with the idea of privacy rights, and we may agree with substantive due process, there's an aspect of that that removes the power from the legislature to make those laws and puts it in the hands of basically 9 individuals who are not elected and have no responsibility except to either themselves or the legal community. So I kind of think that that's something to really kind of talk about and think about. I think that we may like the result in Griswold versus Connecticut, but is liking the result good law?
Probably overall not, because I'm thinking, Griswold, and I can't think of a court case, but I think you always have to be careful of, and I can't think of an example, so you know this better than I do.
That's fine.
But the results of what a judge says, even though you like the result, those same arguments could probably be used in another court case and have a result of something you don't like. And I can't think of an example. Okay, I wish I could.
Well, I'll give you an example. I'll give you a
Okay.
good example is this, okay? Let's say that you're a juror on a case and a person is charged with possession of a large amount of marijuana. And then when they come in and testify, their testimony is, hey, yes, I had this large amount of marijuana. I never sold it. I only was keeping it for personal consumption. And I shared it with family members who had medical issues that I was giving it to them for. You're a juror on that case. The law is that a possession of a certain amount of marijuana over a certain weight is illegal. It's against the law.
Yeah.
Now, if you said, yes, it's illegal, but he wasn't using it for anything but his own personal purposes, I'm going to reject the law and I'm going to find him not guilty. Now, although that may be a good decision, it may even be a moral decision, is it right to reject the rule of law to do what you think personally is right?
Well,
Would the
this doesn't really
punishment
answer the
have to
question.
be the
Oh, go
same?
ahead. Go ahead.
Carol, I think you got some point. Go ahead.
Would the punishment always be written down and be the same? Or could the judge give a punishment that is due to that person? He did go against the law, and it has to be recognized. But when you have states surrounding Ohio that make it recreational and everything, I mean, marijuana was a sketchy one to bring up, because you know darn well it'll be federally okay in 10 years or whatever. But what I'm saying is, here's a gentleman or a person who was sharing it only with family for medical purposes. You have no way of knowing if that's true or not. You can't prove or disprove any of that. You have to go by the word of the person who is in court here. So I think that with that being said, he needs to realize his wrong. And I guess you can't advise him, hey, keep it under whatever the amount is. And I think in the state of Ohio, there is no amount. But I mean, you can suggest to him, follow the law. Our laws in Ohio are these things. But my question is to you is, do you have to give the law is such written and the punishment is written? Do you have to follow through with the punishment as it is written?
Well, so that's a great question. I'll open it up a little bit. Is that the fact of the matter is that on a felony level, so let me put a couple things first. Under 100 grams of marijuana is a minor misdemeanor punishable by a $150 fine. For a long period of time, for about 20 years, there used to be also an associated license suspension with that. That has been taken away, and there's no longer a mandatory license suspension with the possession of that much marijuana. And that's a large amount of marijuana, I will tell you. But we were talking on the felony level here is what I was talking about. Felonies in regard to that fall into 5 different categories: F1, F2, F3, F4, F5. And actually, this is a great discussion because we're opening up a discussion that is currently a huge discussion in the area of criminal justice in regard to the incarceration of people and what we should do in regard to incarcerating people. How should we handle those things? What should we do? So, and I use marijuana because it is a sketchy area. You do have states having different rules all over the place. And I want to use that kind of as an example to a point. There is a good argument that allowing states to be the incubator for ideas is a good thing. That, you know, this is one of the ideas of the anti-federalists, is what the idea was, is, hey, let the states do what they want. Federal government needs to be smaller. And if the federal government's smaller, the states can experiment and do the things they want to do.
Yeah.
Now, I don't know that that's exactly happened. I think it's more along the lines is that the federal government has become unable to respond and maybe through gridlock or whatever you want to call it, has able to respond in a nuanced way. And so the states have been more responsive to certain kinds of change. You know, it's not just marijuana. I think that's like one example. It's a whole host of services that we expect out of the government that states are handling in their own way, shape, or form. So back to the situation you asked. So in regard to, the judge has in Ohio these 5 different levels, F1 through F5. In F5 or in F4, the law presumes that I will not send the person to prison. There is a presumption against a prison term in that. In regard to an F1 or an F2, there's a presumption I will send them to prison. And then in F3, there's no presumption either way. So I always have the discretion of whether or not to send someone to prison. There are some offenses that do have what we call mandatory minimums. There are less and less of those, and there may be more and more of them going away. But understand that's kind of what do you want to call it? That's a kind of an ebb and flow of society. If you went back 30 years ago, people were advocating for mandatory minimums because they don't trust judges. They don't trust judges to make a decision on what should happen to somebody. And everybody has an anecdotal story about the drug dealer or the bad person who got out of prison and went and did another crime that was terrible. And but for the judge letting them out, they would not have committed that crime. I think that's always a thing that's out there, and that's part of the whole criminal. You hear it today. This is a popular thing: is that we've got too many people incarcerated, and so there's a refrain out there that we really need to treat people. We need to focus on treatment. Well, we've done a lot of that, and we are continuing to do that. But so that comes down to the question is, who should go to prison? I don't know if you want to open that box, but we can discuss that.
So, Judge, you said F1 and F2 is a mandatory prison sentence. And are there minimums and maximums on F1 and F2? And
So what I said was, and I want to make sure I'm clear on it, an F1 or an F2 has a presumption of prison. There's not a mandatory minimum, except in certain cases. There are certain offenses that have a mandatory minimum. Obviously, aggravated murder does, certain rapes do, and certain other offenses. But there's a presumption. And so, for example, on an F1, if I impose a prison term, it starts out at 3 to 11 years. On an F2, it's 2 to 8 years. So if I impose a prison sentence, I'm going to be imposing 2 years on an F2.
we had a case here in Toledo several years ago, and I knew this individual. His name was Timothy Saboro. I don't know if you're familiar with the case or not, but he represented himself,
He shouldn't have.
which was a big
Big
mistake.
mistake.
He held a young lady in the basement of his home and was, I guess, trying to reprimand her or something, but he had her chained. And anyway, the sentence ended up being life imprisonment without any chance of parole. I knew this individual as a young man because we were in the same National Guard unit, but I hadn't been in touch with him for many years. I thought that sentence was very severe. He didn't kill anybody.
Sure.
Sounds like you're involving mental illness now. That's a whole
Yeah.
new ballgame.
Yeah.
Well, he represented himself. He probably would have had a case for that. He had the Bible in his hand the whole time he was in court. He followed. He was really into the Bible, and he was that way as a young man. I remember him in the National Guard unit. When I've written some letters to him in prison, and I think there probably is a mental problem there, and just a life imprisonment without any chance of parole in that case just seemed very severe.
Well, it's hard for me to comment on what another judge does, and I'm not going to, but I will tell you this, okay? Is that the things that you consider as a judge is that what's the danger of this person? We don't know the circumstances. We don't know the situation.
True.
Now, in regard to representing himself, I know if that judge did everything that I know that other judges do, is that you go through a long discussion with the person. In my case, I've had some people who wanted to represent themselves. I allowed them to do that, but I had a counsel along with them on the side for any kind of advice.
Yeah.
And I think that's something that's necessary and responsible to do. But at the same time that, we guarantee people to have their own attorney, they also have the right to not have an attorney.
Yeah.
It may be a dumb decision, And I get that. I mean, I think if you sat and watched one judge for an entire day on a sentencing, just watch the sentencings or whatever,
Mhm,
you would find sentences that you thought were too harsh or too
mhm,
lenient or not enough, whatever. And I
mhm.
think that's what happens a lot of times is people get upset um, about what's going on, they get upset about a circumstance because they're so emotionally connected to it.
Yeah.
And so that's kind of the how it works. I mean, and that can be frustrating from the public standpoint. The public, for example, let's just say that individual, and I'm just giving you a scenario, kind of a devil's advocate.
Mhm,
Let's say the judge, instead of life in prison, gave him 20 years. And he gets out after 20 years and he goes and harms someone else, or maybe he kills someone or something like that.
mhm.
Then in hindsight, we're saying, well, the judge should have given him life in prison. The judge was wrong for that. I don't know what was in front of the judge. I don't know what kind of information the judge had. But I'm guessing that when a judge imposes something like that, particularly on somebody who is representing themselves, that maybe they've seen something that concerns them about future crime.
Mhm.
No, you got a good point there. Because it's hard for me to think outside of my box. I'll admit that, but and the box I'm in is, you know, we can rehabilitate, people that murder, and I don't have any problem if they're rehabilitated and it looks like they can be back in society, but it's really hard for someone who didn't kill a person that there's no prospect at all. And it's hard for me. I'm not a judge, and it's just a mental thing I have, that's just my values.
I,
Um,
I
that's, but I wasn't there and I don't know all the circumstances. And at some point, I guess you have to let it go. Um, and I know there's groups and organizations. Uh, I've heard of the ones with the death penalty that they Innocent Project or something, and maybe this guy is a good candidate. Not that for something similar. And again, you sometimes you just got to say, I don't know, but it's hard because Carlton knew him, But and you got to balance that against what I think the law should be, and just because I think the law should be a certain way doesn't mean it has to go that way. Heaven forbid. It's hard. It's hard.
I have a
so
question, Judge.
yeah,
When you have a case like what we were just speaking of,
yeah.
you have all his prior history as far as if he was involved with courts or this is that. I want to ask, do you also or could you get all of his medical and psychological history as well, even though the HEPA rule is there? Can you over supersede that so that you
Oh,
have, I know they separate the psychological notes, and those are the notes you need to look at a person thoroughly.
oh,
Well, I can order a psychological assessment, and I have. And so, yes, the answer is yes. I would have that psychological assessment in front of me. I would have their past contact with the criminal justice system. I would typically, in a pre-sentence investigation report, I'm going to have their family history, what the circumstances of their childhood was. I'll have statements from other people who know them. I had a sentencing like that on Friday last week, and so that was I had a whole host of information. Must have had 20 letters on behalf of the defendant, but then I had victims who came in and three victims who testified about the substantial impact on their lives of the offense and how that had damaged them and affected them for the rest of their lives. So, yeah, and the answer is yes. I would have both medical and psychological information as long as the defendant had signed a release and the defendant had provided the information. Now, unless I order a psychological evaluation. In the particular case that they were talking about, I don't know if a psychological evaluation had been done. It sounds like it would be inappropriate. But once again, it's whether or not he's willing to participate in that psychological evaluation. Sometimes people don't want to participate in that.
You know, just as a side thought on this is, you know, your position is elected. And when people elect their judges and that, we look at that whole person as well. And we decide that we think he's a moral Christian that would do his best when he looks at everything. And I think that that's some of the faith we have in a way America is run. And that means a lot to me as a voter. And that's how I would vote. I look at that person, where he came from, his family, his stability, and how I think that he thinks like I do. And honest, that's how I look at people. And so when you have a case presented to you like the one we spoke, I think that you would take in all of that information and you would think very clearly about what is the best for society and for the patient or the person. And I think that's really important. That's what makes us run very well here in the United States.
I agree with you. I agree with that assessment. It would be nice if everybody kind of took that time to get to know a judge, to be able to vote for them. Unfortunately, I think within the political system that it's hard to do, and it's hard to get to know who the judges are. I always, you know, being a judge, I would say, is a difficult situation as opposed to being in the other two branches. If you're a representative, you're representing the ideas and the positions of your constituents. Many times you can just do a survey and you can do a poll and, okay, well, the majority of my citizens are in favor of X, so I'm going to be in favor of that. As a judge, you don't get to do a poll, and you have to rely on certain things that are inherent with you, understanding the law and such. And I'm going to tell you, you know, it's funny is I spent 20 years as a prosecutor. In that 20 years, I had people in front of me who were both defendants and victims of an offense. And depending on where they are, they have a totally different version of what punishment should be. If you're the defendant, boy, I really need a break on this. If you're the victim, I hope you give that guy the worst sentence that could ever exist. And so weighing that, you know, I kind of joke with the other judges about this. I always say this, and this is where I was kind of getting at a little, is where judges can get a little off the rails, is that I always joke and I say, you know, in the French Revolution, the first ones who were killed were the judges. And what was going on was the judges were not being sensitive to the community, to the society, and were in creating their own law, basically based upon their own way of doing it. And so that's why in the French Revolution, not only did they overthrow the state, but they completely destroyed the state and came up with their own state, which, you know, led them open to being a totalitarian state under Napoleon. So that's the danger. I mean, there's an aspect of it when you look at our revolution, when we held on to our legal system from England, we kind of ensured the stability of our state. You know, when you completely reject society or the structures of society, you really invite the danger of chaos. And so those are some of the things you always have to weigh. I think there's we're seeing that today. We can see that in the ideas of defunding the police. I understand where people are upset with the police and some of the structure there, but at the same time, when you say defund the police, well, then you open up a whole new can of worms in regard to chaos. And I think I went way beyond what we were supposed to talk about.
No. It's not a question of what we're supposed to talk about. Please. No, I mean,
Very
getting back to electing or voting for judges, it's taken me a while. I'm embarrassed to say how long it took, but I'm really trying to research the judges. And you're right, it's very difficult. You go to the League of Women Voters, and they're just answering questions.
Sure.
And you try to go back to see their record, and it's not readily available. And it's a challenge. So I just do the research the best I can and just vote, but it's hard. It's
Sure.
hard. I mean, I spent several hours going to what I thought were reputable sources, and you still can't, and I went to all these things, and I still said, well, you just do the best you can,
Well, I think that, that's one of the interesting parts is that, okay, in the United States, there are over 500,000 elected officials throughout the United States,
Really? Wow.
more than in any other country in the world.
Okay.
And so, talk about a society that relies upon elections. We rely upon elections.
Yeah.
And so from that perspective is that you've got to kind of say, well, that means it's got to be difficult on the voters because the voters need to make decisions based upon the people that they want there. If they're willing to put in the effort, then they'll get good candidates. If they're not, then they'll get what they get, I guess. And to a point, a representative society, a representative democracy like we're in, a republic, requires you to have a little faith in other people. I sometimes wonder if we've lost that. When part of the reason we have political parties is to help us make decisions, is that if a person belongs to this political party, then they have certain political beliefs that we may or may not agree with. And therefore that helps us in making our decisions. And then we look at other things. Does the person belong to this association, go to this or whatever?
Oh, yeah.
That helps us too.
That helped. Yeah.
In past years, we've also had the benefit. We live in North Toledo, and there's a Friendship Park Community and Senior Center that always organizes and requests all the candidates to come to a meeting and locally, and we've always attended those. So we had, that personal touch, being able to. This first they would give their presentation, and then there'd be Q&A. So, but this year because of COVID, they didn't have it.
Yeah, we would have school board candidates, which was very interesting, and you could see differences among them, and they weren't shy about it.
And judge candidates.
And what was that other one? It has something to do with, it's just terrible. It has something to do with the schools, but they were with the different districts, and they had responsibilities.
Council people.
Yeah.
City council.
Yeah. And they would, and a lot of them would hang around afterwards, and you could approach them and ask them anything,
I would tell you that in my experience, anybody who's running for elected office is always willing to entertain questions, discussion, or anything. And we live in a world where it's really easy to have those discussions.
Yeah.
So, email, there's always the ability to email, different kinds of contact are always available. So I think that, that's just a thing that's always a resource. So I wanted to go over this, is that there's a lot of discussion today about the Electoral College.
Oh.
And I think that people are frustrated with the Electoral College. And I can understand that. I want to, people are, one of the comments about the Electoral College is, well, the candidate who got the most number of votes may not win because of the way the Electoral College is weighted. And you'll see commentaries, discussions about it out there all over the place. And I guess what I want to say is that it's important to look at the context. This is where the context of the discussions that created the Electoral College are very important. And looking back at what happened in 1787 is just as relevant today. The names of the states that were powerhouses in 1787, really there were one of them still the same powerhouse, New York. New York is a powerhouse of electoral votes. But today we also have California, Texas, and some other states. But those are your big powerhouses. In 1787, your powerhouse was Virginia and New York. And a lot of the other states just didn't have as much power as those states did. And so the argument back then is that if we go purely on a popular election or a popular vote, then those two states are the only ones that are going to matter. It's basically candidates will either come from New York or Virginia. But if we go on an electoral college, then it's going to give a better weight throughout the country and give a little more power to smaller states, which might not have any kind of and the issues that are important to those smaller states. So for example, if we were on a purely popular vote, issues that are important to Iowans would never make it to the forefront, or would rarely make it to the forefront of discussion. Certain issues in Ohio and Michigan might, because there's a large number of people who can vote there, but definitely the issues would be weighted more towards a California, New York kind of issue, as opposed to when you're talking about electoral college, you have to create a map, a plan, a political plan to be able to incorporate everybody. The whole idea was to have to create a coalition so that you had to be responsive to the issues of different states throughout the nation. And I don't know that that's changed. I don't know that that's changed at all. And so creating a coalition that builds electoral votes is still important today, and maybe more so important. And so I wanted to at least have that discussion a little bit to say that, you're going to see a lot of discussions out there, a lot of people pointing to getting rid of the Electoral College. But if you look at the Federalist Papers and you look at some of the other discussions that took place in 1787, you can see a lot of the discussions that are being done today were talked about then. And that's why they ended up coming up with what we call the Electoral College. And I don't know how anybody feels about that, but I wanted to at least make sure.
Judge, I have a question about that. The delegates who cast those electoral votes,
Yeah.
are they 100% obligated to cast them based on the popular who won the popular vote within their state?
So that's an interesting question, and that's a state by state. Each state gets to make the determination. The answer is that a electoral voter, somebody who's in the Electoral College, is morally obligated to vote for the person receiving the most votes, but not always statutorily. Now, I will tell you, some states have adopted a new law. The new law is that, and this is, I think there's 12 or 13 states that have done this. A elector in the Electoral College must vote with the popular vote of its state unless the popular vote of the state is different from the national popular vote. So for example, let's just do an example of this year. Let's say that for I'm just going to give you an example, okay? Let's say for some crazy reason, Massachusetts votes for Donald Trump, that the popular vote in Massachusetts is for Donald Trump. Now, I know you can't imagine it, but let's just, okay, imagine that for a situation. But let's say nationally, Joe Biden wins. Well, according to the law in Massachusetts, the electors, instead of voting for Donald Trump, have to vote for Joe Biden.
Huh.
Joe Biden won the popular vote, then the electorates in Massachusetts would have to go that way also, even though Trump got the popular vote in Massachusetts.
Right, or we vice versa, and this might be a little more imaginable. Imagine this. Imagine for 1 minute that Donald Trump wins the national popular vote. But in Massachusetts, Joe Biden wins the popular vote for the state. The electors in Massachusetts will have to switch their vote and vote for Donald Trump. Even though, now imagine that situation. Imagine that scenario in
Wow.
Massachusetts.
And there's about 10 or 11 other states that have enacted that?
Yeah.
Wow.
Wow.
Imagine what happens in that particular situation. And those states who adopted it in the face of what happened in 2016 and basically what happened in 2000. But there's another scenario out there that how would the state of Massachusetts react? How would the citizens in the state of Massachusetts react if their electoral votes, because of a national vote, went to a candidate that the majority of the people in that state opposed?
Going back in history, the southern states, as I understood it, the number of electoral votes that they were assigned included the slaves.
It did.
They were only counted as 3/5 of a person.
Yes.
How about other non-voters or non-registered voters? You didn't have to be a registered voter to count as a full person.
No, it had nothing to do with the ability to vote.
Just
It
strict
was
population. You have to be a citizen, though.
Well, it's a good question.
I mean, if you're a resident alien,
Oh, you're included in that. You're included in the census data. It's all based on the census.
census. Okay, that was my question.
Yeah, you're based on the census data.
Okay.
He's looking for someone to answer his question.
How did that come about? The states putting in that in?
Which
Where
what are
did
you
that
talking about? The
come
3/5?
Pardon?
The 3/5?
No. About what you were speaking about.
Oh,
with the
how did that?
electorate. Right. How did that come about? That seems so unfair.
Well, that came about, and basically it was a reaction to the election in 2000. In 2000, Al Gore had won the popular vote nationwide. So if you looked at the national vote in 2000, Al Gore had won. And, but in the end, just a minute. Wait. I'm just trying to get the numbers, okay. So here we go. In the presidential election in 2000, George W. Bush had 50,456,000 votes. And Al Gore had 50,990,000 votes. So he had more popular votes in the nationwide counting. But George Bush had won the electoral votes ultimately. And so many states, not liking that, said, you know what, we've got to change that. And so they decided the only way to get rid of the Electoral College is to change the Constitution. But you could change the way that the Electoral College apportions its votes within a particular state. And so that's why those states did that.
Was Florida one of the states that changed that, Judge?
No. Just a minute. me see.
I probably should know this, but where does Ohio stand on this?
Ohio votes with the popular election of the popular election within the state.
All or none.
Yeah. So
Yeah,
they're not one of the 11 or 12.
no.
So the Supreme Court has ruled that the Electoral College voters can be forced by the state to require them to vote for the state's popular vote. So there's been along the times, there's always been the fear of the faithless electoral voter.
Mm.
This has always been a situation out there, and it's never occurred, but it's always been possible.
Mhm.
So, Judge, if Biden gets the total popular vote nationwide, and then these states, the 11 or 12 that you spoke of, some of those statewide have a majority of Republican popular vote, but then they switch it over, to coincide with the national Democratic. Would the Supreme Court get involved in something like that?
It could. You'd have to have a controversy. You'd have to case. I don't see it happening if Biden wins the popular vote. I see it happening if Trump wins the national popular vote. And because all of the states that have changed it are historic or are typically within the last 20 years, what we call Democrat states.
Mm.
Why do you think that is?
What's that?
Why do you think that is?
Well, I think that is because in the since
You can like the outcome in 2000.
since 2000,
Probably.
Yeah.
well, since 2000, there's only been one election where the Republican has won the popular vote, and that was 2004. So in the last 20 years, we've had 12 years of Republican presidents and 8 years of Democrat president, and only one of those times did the Republican win the national popular vote.
So if Trump won the total national popular vote, but then lost the electoral vote because of those states, that's where the Supreme Court would come in.
The Supreme Court could if somebody challenged it, if they wanted to sue and say. So I imagine a situation, and this is all in my imagination, in my head, just like all those talking heads on television. So, I can, if Trump won the national vote, the national popular vote, and Biden won Massachusetts, Massachusetts would have to switch its electoral votes to Trump. I can see a situation where the electors in Massachusetts would refuse to do that, and then the Republican Party in Massachusetts would sue to make them do that based upon the law.
Okay, I see.
But meanwhile, who gets that vote? Who's going to be president? Meanwhile, while they're going in through the judicial system, which takes years, we have the wrong president? We have the right president?
No, I would tell you, okay, if an election gets down to it and if Trump has won the popular vote, it won't, I think it would, if he's won the popular vote, then he's won enough electoral votes to win the presidency. I don't think it's a real issue. What it's going to be is more of a symbolic thing that electors in Massachusetts will not want to follow the law.
Well, I see more controversy and more uprising in this election. I don't know if it's because I'm older or because it's more verbal, more media, but if there's can be some stinkery things going on, I think that would happen.
I would tell you that you may, or I think that we all kind of see it from that perspective. And I'm going to agree with you that it's very controversial. But if you look at the 1876 election, that was a really controversial election. And if you want to look at some other elections, the election in 1800 between Adams and Jefferson, that was very contentious. And there's a real question whether Adams would, really actually transfer power.
So in 1876, Judge, there were 4 candidates for president, and the one that got the most electoral votes did not become president.
That's true, right? Because he didn't have enough electoral votes.
That's right.
And so it went to the Congress, and the ultimate thing was that Rutherford B. Hayes agreed to end Reconstruction, and so he was able to get Southern votes.
Wow.
Wow.
Mm.
But I understand that I think a lot of people, democracy is in many cases sometimes pretty ugly. Bismarck's famous comment was, "Those who love the law and sausage shouldn't see it made." And I think that applies to democracy.
Mhm.
I'm thinking back to the election, I believe it was 1988, when Ross Perot ran.
That was
You think he got-
92.
I think he got, what year was that, Judge?
1992.
92. And he received about 20% of the vote.
Yep.
But apparently Clinton got over 50%.
No,
No?
Bill Clinton got about 43%.
Okay, so there was a case there where, I don't know, I guess we have to look at the electoral votes. Didn't Clinton have to receive the majority of the electoral votes in order to?
Yes, and he did.
Okay.
Mm.
Bill Clinton received 370 electoral votes, and President Bush, George H.W., received 168.
Oh, I see. So even Perot and Bush combined didn't exceed Clinton's
Not on electoral votes, but
electoral votes. Correct.
popular vote, yes.
Mm-hmm. Okay.
So I mean, there's a great argument out there, and I know the Bush family is still upset about that, but there's a great argument that in 1992, but for Ross Perot, George H.W. Bush would have won.
Mm-hmm.
And there's an argument there. So
Mm-hmm.
yeah, I mean, that's one of the things is that we get presidents who, Abraham Lincoln was elected with less than popular vote.
Mm. Wow. I didn't know that.
So what was his, I'll get that number.
Well, that was almost up.
So yeah, Lincoln, he had 39% of the vote.
Wow.
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 So, talk about a guy coming in with not much of a mandate.
You ran against the short little guy, Douglas, Stephen Douglas. Wow.
Yeah, but Douglas didn't end up getting the most. Actually, Douglas got the least amount of electoral votes.
Huh.
That's the other thing. So
Huh.
this is an interesting part about it. Abraham Lincoln had about 1.8 million votes. Douglas had 1.3 million votes. Lincoln had 180 electoral votes, whereas Douglas only had 12.
Wow.
The person who had the next largest amount of electoral votes was John Breckinridge, who had 72.
Hmm.
And then John Bell, who had 39.
Mm-hmm.
So Douglas did not have as many electoral votes. So it was kind of a, once again, and Lincoln didn't win a single Southern state.
Yeah.
Do you envision, Judge, that in our lifetime, your lifetime, that the Electoral College will be abolished?
I hope not. Um, I, I hope not, and I think that I hate to say that I hate to say that something won't happen in my lifetime, because so many things have happened in my lifetime that I didn't think would happen in my lifetime.
Yeah.
I would hope that that wouldn't happen.
Yeah.
I'm all for innovation in elections. You look at it, there's a lot of ideas out there. This is another place where states are really inventing and doing some neat ideas.
Yeah.
There's the rank order. So in California and Minnesota, you can vote for somebody. Here's my first choice, but here's my second choice. And
Oh,
what
yeah.
that causes is sometimes two candidates to join together who are both going for the same seat, but to campaign together. So that creates a whole new situation there.
Yeah, there's some countries that do that.
And I think it's a good idea.
Yeah. Oh, I don't know if we have enough time, but I put something in the chat box. What are the dangers of proportional voting? You know, like in Ohio, if one candidate gets 2/3 of the popular vote and the other candidate gets 1/3 of the popular vote, and the electors go 2/3 for one. And what's the dangers of that? I read a lot about it. I know there's got to be dangers, otherwise it wouldn't be discussed.
Well, two states do it, Maine
Oh,
and Kansas.
oh, okay,
To be honest, I don't know that I see a danger.
okay.
I think that it is, for example, once again, it goes to the states.
Yeah,
and they
yeah,
have the ability to
yeah.
apportion the votes the way they want to.
Yeah,
I want to tell you this.
okay,
This is my final comment.
okay.
For the last 10 years, I've done elections monitoring in other countries.
Oh,
And I've done it in Moldova, Mongolia, Kazakhstan, Bosnia, and Ukraine.
wow.
And what I can tell you is consistent with every one of those countries is a national elections. Everything is run through one national national program. And a lot of people out there would tell you that's what we should have. And I guess if I have an opinion, I would tell you that I don't believe that's true. I think that although it can be confusing and cause a lot of issues, the fact that we have 50 different elections in 50 different states provide us, I think, a better system than one unified national system. That's my position. You can accept that or not.
You're definitely not a federalist.
No, I would say that I
I like it.
well, that's a good comment. I like that comment. I would say that I agree with many things that Hamilton said, but I don't know that I would have been in Hamilton's camp.
Okay.
I think we need a federal government. I think we need it for certain purposes. But I don't know that I think that everything should be in the federal government's.
Painted him in a corner. You.
Yeah, now I got to argue with my wife.
So, hey, I really appreciated doing this. I'm going to talk to Danielle about doing something else on Citizens United and maybe doing a specific thing on that presentation and getting into some First Amendment issues. But I really thank you for doing this, and I appreciate the time everybody's taking.
Yeah, thank you.
Thank you,
Yes,
Judge.
thank you.
Good hour. Good hour.
Thank you so much for sharing your knowledge with us. We really appreciate it. And wonderful discussion. So we'll be back in touch for a continuation of our program.
I appreciate that. And I do appreciate you being patient with me today.
Oh,
Thanks a lot.
no problem.
Have a good day.
No problem.
Thank you.